Welcome back to the Law and Crime Network. I'm Heather Hansen, and we have a brand new, really interesting trial for you. That's what you've been watching this morning, the opening statements of the prosecution in this case of Ohio versus Shawn Grate. It is a disturbing case. It is an upsetting case. It is a disgusting case. But there are tons of legal issues. There are tons of social issues, and there are tons of scientific issues to discuss. And thankfully, I have three fabulous guests here with me during this lunch hour. First of all, I have jury consultant Alan Tuerkheimer, who's going to fill us in on all the ins and outs of how to choose a jury in this so difficult case. I have Nicole DeBorde, who's here with us. She's a former prosecutor, currently a criminal defense attorney. And I have here in studio with me my friend Jonna Spilbor, often here as a guest and also a criminal defense attorney. Hi, guys. Welcome.
Good morning or good afternoon.
Alan, I want to start with you because this jury not only has to listen to really, really upsetting details about these heinous crimes, but this is the first case I've ever seen this happen. They actually are going to have to watch cell phone video of the rapes of the women involved in this case. How do you pick a jury that can be anything close to fair with those types of visuals?
Right. I think the prosecutor is thinking about that phase. Now, from a jury psychology standpoint, anger really causes an impulse to punish. So they're going to ultimately ask for the death penalty. They really want to fire up this jury. Emotions are one thing. Madness is certainly something that exists. But to get jurors to want to punish somebody, that is anger. That's the emotion that fuels it. So I think that they're going to try to use that prosecution to get a jury to decide that this person is guilty, and they're going to reject all the defendant's efforts to say that they're not guilty because of whatever their defense is going to be, and that he's death penalty.
What does the defense do? I mean, I can't even imagine being in the defense position. We just saw that they waived their right to an opening, and I want to ask Nicole and Jonna about that in just a second. But from a jury perspective, Alan, is there a way to ensure, or at least attempt to ensure, that these jurors will be able to put sympathy aside, put anger aside, and find this case based on the law?
It's a very difficult task. Now, I'm sure during voir dire they made commitments to that, and to make a commitment in open court, it's more likely you're going to stick with it. But I'm not sure why they did that. Now, there's some strategic reason why the defense didn't give its opening. But from a jury standpoint, they've only heard one side, and certainly if you ask the jurors right now if they were polled, they would unanimously say that he's guilty beyond a reasonable doubt. There's no question. So it's really a hurdle the defense is looking at. Maybe they're just trying to spare his life, and they feel like there's a way to do that without putting on an opening and doing the conventional rebutting, so to speak, what the prosecution did in the opening. But in jury selection, they did their homework. They seated jurors that were going to wait till all the evidence came in after all the witnesses spoke, and jurors who are going to hold the prosecution to their burden, which is a high burden in a case. Well, I think that's what they're going to try to hang their hat on.
Nicole, what do you think? Why do you think the defense decided to waive their opening in this case?
It may be that they will try to open before they put on their own case in chief. Sometimes that is a smart move. If you don't want to reveal what sort of defense you are planning to put out in front of the jury, you may wait to actually do the opening argument until it's your turn to present your case. And so that may be happening.
Yeah, Jonna, we also know that there's this delay, sort of, because there's some scientific witnesses that are going to testify and that they haven't had the chance to review all of the evidence. Could that be another reason why perhaps the defense is waiting?
Oh, yeah, absolutely. That could be another reason why. And like our other guest said, he has another opportunity to make an opening statement, and he might as well wait until before his case is going to begin. Now at least you know what the entire state's case is. Plus, this is such a sensational and odd case. And keep in mind, the jury's been picked. They have some idea what the defense is going to be because you had to voir dire them.
That's right.
And even though you don't try your case in voir dire, your jurors have an idea what your defense is going to be.
That's a really good point, Alan, and I want to go to you on that. When you've got a defense attorney speaking to a jury during voir dire, they certainly, in this case, we know part of the defense is going to be the insanity defense. So they certainly would have, I would imagine, asked the jury about, are you open to the insanity defense? Would you be able to find that the defendant was actually insane if the facts and the evidence and the law were to support that? How do you, as a jury consultant, help lawyers to determine whether or not people are sort of just saying that because they want to get on the jury, or saying that they can't because they want to avoid being on the jury, or those that actually feel that way?
Right. It's certainly something, like you said, that has to be addressed. And I think you just have to listen really carefully to how they respond and what they say about it. You have to, it's better to find out in jury selection and put the vulnerable in your case forward so that you can get rid of and strike the jurors, because you're not basically getting to choose your jury. You're case selecting jury. It's jury case selection.
Right.
You'll want to have lawyers talk about, okay, this is what our defense is reviewing the defense and getting a reaction. Now, you just look and see how jurors react. Sometimes you might have a juror that pauses a little bit and says, yeah, I guess I could consider it, or
Alan,
Alan,
I have to jump in on you only because the Tex McIver case that we've been following for so long here at the Law&Crime Network, the jury is back and they've let the judge know that they're deadlocked. I think we can go straight to the jury, to the courtroom. Is that right, guys? Okay, we're going to throw you straight to that courtroom to see what's going on there. All right, ladies and gentlemen, so here we have a situation where the jury has come back and they have said, we don't see a path to overcome our differences on the defendant's intent on counts 1, 2, 3, 4, and 5. Now, the judge is giving the defense attorneys the opportunity to discuss how they'd best want to respond to that statement. There's a number of options here. This jury has been out for well over 20 hours. And so the idea of asking them to continue to deliberate is not as attractive as it might have been some time ago. But however, it may be something that they want to attempt rather than risk a retrial of this case and a mistrial. On the other hand, they could have the jury come back and get a charge that they should continue to deliberate. They also could have them come back and recharge them on the intent. But I've got to say that it has been pretty clear that this jury is confused, to say the least, about the law in this case. And so I don't know that that type of confusion can be overcome. It may well be that it's just one or two jurors who are confused, but for right now, these defense attorneys have a difficult decision to make. And you see them there, including Tex McIver, in that decision. Remember, he's an attorney as well and has been, I think, quite adept at stepping back and letting his attorneys do their job. But it's certainly appropriate for them to ask for his input in responding to this really important question. If we have a hung jury here, we'll see. We may end up seeing this case again here on the Law&Crime Network. All right, ladies and gentlemen, so the jury seems to be deadlocked on the intent issue on counts 1, 2, 3, and 5. Jonna, I have Jonna Spilbor here with me in studio. Jonna, what do you think? What would you do if you're on the defense side?
This is really tricky because on the one hand, I would want to hedge my bets and say, let's have a hung jury. Let's have a mistrial, because given this defendant's age and given the fact that, come on, I don't care, the prosecution's got to look at the state of the evidence and say, we couldn't get the job done now. What are we going to change that would get the job done 6 months from now with a 70-something-year-old defendant?
Yeah.
I would say, I would almost let it be hung. But I would make a motion to get my client out of the clink. He's been sitting in jail.
That's right.
And he can't sit in there any longer. So
Yep.
bail him out, set some sort of bail while the DA decides what they want to do with a retrial.
Yeah, I agree with you. That's exactly what I would do. I think at this point, this jury's not going to come to a conclusion on and at least not on the most important counts, and you're going to end up retrying the thing anyway. So I agree that that's what I would do. It looks like they're getting close to a decision. But I also agree with you that he shouldn't be sitting in jail while the DA makes up their mind as to what to do here. Now, if you're the prosecutor, what are you pushing for?
You know, this is tricky because the prosecutor has to know that they did not have the case that it intended to have, right? And not only that, there were a couple of embarrassing moments in the case when a state's witness actually misfired the same gun, which, I think helped the defense a great deal. They know they have an elderly defendant. They know this was a long trial with expert testimony, a lot of resources. I would call it a day.
Yeah, speaking of resources, I mean, a ton of money invested in this. A ton of money is being paid with all the reenactments. Let's see, go back to the courtroom, guys. So we have the judge and the lawyers considering what to do with this jury that seems to be hung. Alan, I want to bring you in. With all of your experience as a jury consultant, what do you think? If you're the defense attorneys, let's start with them. Do you continue to push for this jury to deliberate, or do you give up and go for a mistrial? Ladies and gentlemen, so we are live in the Tex McIver courtroom where the jurors have indicated that they are having a difficult time coming to a decision. They say they do not see a path to overcome their differences on the defendant's intent on counts 1, 2, 3, and 5. We are here waiting to see what the judge and lawyers will do with that. The judge, you see him there looking at his computer. He is looking at what's called the Allen charge. That is the charge that is given to jurors when they can't come to a conclusion, and to encourage them to go back and continue to deliberate. Now, the defense attorney made a good point, which is that the Allen charge does often lend itself to appellate issues. If you don't give the Allen charge in an appropriate way and applicable to the juror's specific issue, it oftentimes leads to an appeal in the future. So the judge is taking advantage of technology. It used to be that these things had to be pulled out in books, and he's looking live at the charge that is applicable in the state of Georgia to this type of situation. And then together with the attorneys, he will attempt to craft a charge that is appropriate given their problem. One of the issues here is that the closings in this case were last Tuesday, and that means that also the charge on the law was given to the jurors last Tuesday. So they have very likely forgotten much of what they heard, and while they have come back with questions, getting that information in piecemeal is certainly not uber helpful to help jurors overcome any misunderstandings or any arguments over the facts or the law. So we will wait to see what the judge decides as to how to craft the Allen charge, and I'm sure we will hear from both defense and the prosecutor as to their input in that crafting. Ladies and gentlemen, I want to bring in Nicole DeBorde. She is a former prosecutor, currently a criminal defense attorney. Nicole, we've heard from the defense quite extensively on this, but the prosecution had less to say. What do you think the prosecution's thinking at this point?
You know, it's hard to know. What the lawyers are always thinking in this circumstance is, what is the split? Who are we going to be trying to push in what direction? In other words, are there jurors out there that are thinking, for the majority, that they're interested in finding him guilty of some of these counts? Or are the majority of the jurors thinking they do not want to find him guilty? They want to find him not guilty. And so it's always a tough question for the lawyers to answer. Do they want the judge to give this Allen charge? And an Allen charge is also known by lawyers as a dynamite charge. You know, what that is an instruction that tells the jurors, you need to go back in there and deliberate. If another jury hears this case, they're going to hear the same facts that you heard. They're going to have to do all of this again. Do what you can to come to a conclusion. And the reality is that defense attorneys especially don't like the charge because it causes jurors to feel a great deal of pressure to come to a verdict. And this means that someone will likely be giving up their own opinion to do something that they're really not wanting to do.
I'm back with all of my guests. I have Nicole DeBorde, who we were just talking to, Jonna Spilbor here in the studio with me, and Alan Tuerkheimer, a jury consultant who probably has the most insight, though it's really hard to say what goes on in any jury room. But here, Alan, you know, there's a chance that, as Nicole just pointed out, it could be just one juror who is the problem juror here. How does a dynamite charge, as Nicole called it, that's what the Allen charge is often called, does that really make a difference if you have just one juror who is not giving up on their position?
It really depends on the personality characteristic of that one juror. Now, up to this point, they haven't caved. So is it likely now after this charge that they're going to cave? Not really. So it really just depends on what the split is. Is it 11-1? Is it 6-6? But yes, if it's one juror, maybe this puts more added pressure. But if this juror has withstood pressure up to this point, they probably will continue to do so.
I want to get all of your opinions, and I'm going to start with Nicole and sort of just move down the line on giving the jury a copy of the charge. Because so many times when we see this happen in my own cases and here, I think that if they had a copy of the charge in writing, so many of us are visual learners, that it would be helpful in these situations. Nicole, I want to start with you. What are your thoughts on that?
So the jury charge usually does go back with the jury and into the jury room, and then the foreman can use it to talk about the issues in the jury charge, or all the jurors can look at it and read it and take a look at it. And ultimately, the verdict form is at the end of the jury charge, and that's where the jurors sign off that they've come to a verdict.
Yeah, I think it depends on jurisdiction, because in my cases, that's not the case. Jonna, do you think that would be helpful to this jury? Because I don't think that they have that.
In this jury, I think it would be immensely helpful, because where I'm confused is I can't tell whether the jurors are having a problem determining the factual issue of whether there was the intent necessary, or whether they're struggling with the application of the law of intent to the facts of the case. If it's a factual discrepancy, I don't think anything's going to change their mind. If they can't put it together, then maybe having the charges back there would be helpful.
Well, and the two are so intertwined, right? Because if they're not applying the correct law, then the facts aren't being well applied. Alan, do you have any experience in sort of comparing when jurors get the charge in writing and when they don't, and how that sort of plays with them when they're back there in that deliberation room?
I think there's more thorough deliberation with the charge, because think about it, they're not lawyers, they don't talk about this stuff. It's so new to them and complex. So the poor person on the Boyovich trial said, he felt like it was giving the keys to the space shuttle and saying, here, go fly it. So in mock deliberations, jurors refer to the instructions all the time, and they're usually pretty diligent in relying on them. But yeah, I think it's really helpful to have the ability to refer to that.
Yeah, it certainly seems to me that it would be helpful, though to Jonna's point, we don't know whether it's a factual issue. It does seem as though the questions are lending themselves to it being a legal issue. But Nicole, when you have a situation like this, I was saying to Jonna while we were watching, these attorneys are exhausted. They have been on trial for, I guess it's been well over a month or close to a month. And there's got to be some part of them that just wants to say, Uncle, let's go home.
Right. No, exactly. And, I can tell you the attorneys at the table, they want to do the right thing for appellate purposes. And, of course, they're going to object to the judge trying to force a verdict, especially if any of the attorneys have any idea what the split might be. And sometimes you get hints from the way the note is written or who signs the note. Sometimes you can get hints from, reports coming back into the courtroom or when the jurors come back into the courtroom. I mean, it's like reading tea leaves, but they may have some idea what the split is. And this makes the decision sometimes a little bit easier. Right. That said, while the defense is wisely saying we object to this forced, jury charge, we forcing of coming to a conclusion, they probably just want the jurors to come to a conclusion.
Right. I mean, they're ready for it to end. But Nicole makes a really good point, Jonna, because being in the courtroom is different than even us watching it on camera. Because when you're in the courtroom, you get to see the jury note. And to her point, oftentimes we will know, in my cases, who the foreperson is by whoever signed that note, and perhaps think that foreperson may be controlling the room a little bit more. There are some things to be said from that. So being in that courtroom and seeing those notes, it certainly gives you some insight that we don't have. Do you think ultimately, after them having been out since hearing closings last Tuesday, do you think this jury is really going to come to a verdict here, Jonna?
No. Just to be honest, I really don't think they're going to. And again, in this case, I'm not so sure the defense wants to push this. They might have an idea not only who the foreperson is, they might have an idea who, if there's one holdout or maybe two, because it's usually not half and half, right? There's usually one or two people on the juror who are holdouts. They might have an idea of who that is. And then the comments from the prosecutor, basically, I don't want to be offensive here, but he was kind of calling the juror maybe not so savvy.
Right.
These jurors haven't been jurors before. Like, a lot of us haven't been jurors before because we're smart enough to get out of jury duty. But you don't insult the jury. This is not a failure of the jury. This is a failure of both sides if the jury can't figure out how to mesh the facts with the law.
Well, and that's a really good point, because Alan, I wonder what the numbers are on jurors who are actually repeat jurors. He makes the point that these jurors haven't been jurors before, and we do sometimes see in cases where jurors say, yes, I've served before, but for the most part, aren't most juries made up of people who are meant to be completely naive to the ins and outs of the legal system and bringing just their common sense to bear?
Great point.
Yes, and if they previously served on a jury, they didn't serve on a case like this.
Right.
Presumably they would have been struck. They could have served on a rear end collision case where somebody was asking for $10,000. So I do think that even if they did have prior jury duty, a lot of it would transfer over. Maybe some of the dynamics would, and a person who has prior experience might use that to elevate their own stature with the jury to say, well, this is how it should go. Certainly, it's very unlikely that somebody's on this jury that previously served, but they went far, didn't have a verdict.
You know, it's interesting to me because one of the things Jonna and I spoke about that we were incorrect about is Tex McIver is actually out. He's no longer in jail. So, Nicole, given that fact, given that if you're the defense attorney, your client is now, living at home, does that make you lean one way or the other as to whether or not to push this jury to a verdict?
Sure. I mean, the reality is if there's no conviction and he's on bond, he'll very likely continue to remain on bond. And so a hung jury just means the case goes on. And that certainly could be in the back of their minds and whether or not they want this jury to reach a conclusion.
Right. And Johnny, you pointed out earlier, given Tex's age, at 75 years old, it's one of those. And we've seen this with other cases where when you have an older defendant, that certainly comes to play in your consideration, doesn't it?
Absolutely. You don't want to be expending all the resources necessary to have another trial. This was not a short trial. It was a lengthy trial. When you have a defendant who's already exceeded the average lifespan of a man. I mean, you really don't, because you could be in the middle of a trial and something terrible could happen. The prosecution really has to look at everything they presented and decide whether or not it's worth it to go forward. I say it's not.
Well, yeah, and to retry this case with the same charges, it seems to me, and I'd like to go through each one of you and get your take on this. And I'll start with you, Alan. Do you think that this is a case that was overcharged, and that may be the issue here with the jury being sort of at a deadlock?
It's very possible that happens. Sometimes prosecutors get a little overzealous and they tend to think their case is a lot better than it really is. And so maybe they did that. And so if this was an overcharge and they reached too far, maybe this is the jury and the system's way of having it backfire. So it's a real possibility.
Nicole, if you're the prosecution and you do decide to retry the case, what do you do differently?
It's going to be really difficult for them to do a whole lot differently because there are going to be transcripts of every single witness's testimony. And so this case is going to get more and more difficult for the prosecution as time moves on. If they try this thing again, all of those witnesses are going to be locked into exactly what they said before. And if they don't say what they said before, you can bet that the defense will be cross-examining them about those differences.
Yeah, Jonna, Nicole makes a great point. I have tried cases that were mistried the first time, and man, what a lot more work, because now you've not only got to prepare with the report and the depositions and all of that, but now you've got yet another transcript. And here, a very long trial transcript that you practically have to memorize in order to cross-examine these witnesses and make sure that they're sticking to every point the way they did before.
Yeah, I think it's really difficult to get the conviction that you want as a prosecutor the second time around when you have a lengthy trial like this. There was no aha moment. There was no smoking gun, no pun intended. And even the prosecution's star witness, the driver of the vehicle, the star witness, she wasn't really a star for either side. She kind of helped the prosecution because she was there, but she also helped the defense because she wasn't claiming that he intentionally killed her. And she was 6 inches from Diane McIver's kneecap when she got shot. So I don't know.
Yeah, it's interesting, to go to some of the facts of the case. The prosecution really, took no prisoners here. They tried to make some sort of an intonation that Tex made racist comments in the waiting room, and then tried to make the implication that he was having an affair with the masseuse. I mean, really tried to make this, Nicole, into sort of a soap opera type of case, and seemed to have been sort of knocked down at a lot of those. Do you think that that's something that they regret now, rather than just focusing on the facts and getting the facts in front of this jury?
If they don't, they should. It's not responsible to charge a case, in my opinion, based on all kinds of extraneous pieces of information. This was a tough case for the prosecution from the beginning, and if they had taken a more narrow look at exactly what the facts were that they were going to be able to prove in this case, I do wonder whether or not this case would have ever been charged at all.
Yeah, I don't disagree with you. I think that it certainly, to my mind, was overcharged. And it seems as though every guest that we've had on, this has been a long trial, and every guest that we've had on to talk about this case feels as though the prosecution was sort of reaching, to say the very least. One of the things that was effective, at least in theory, Alan, is the use of all sorts of demonstrative evidence. You know, they had the reenactment of the car at the very beginning of the case, and they actually had Danny Joe come down and sit in the car. They gave the jurors the opportunity to sit in the car themselves. They could handle the guns themselves. They saw Tex's guns. When you're looking at a case as a jury consultant, is that the type of thing that you think is in general helpful to the jury and helpful to having them come to your side if you're able to provide more demonstrative evidence for the jury?
I do. I think it's helpful, but there's a balancing calculation, because you can really overdo it. If you have a strong case, you pick out your best visuals, your best graphics, your best demonstrators and go with there. I think sometimes jurors can get bogged down if there are too many. I don't want to. The balance is the key, because then jurors will think that it's unnecessary, it's extraneous. Not to switch gears too much, but in the Grate case, you were talking about that tape of the sexual assault. If jurors see that, all they need is 10 seconds of that.
Yeah.
So that's a balancing decision that has to come into the prosecutor's mind. Well, how's the jury going to react to it? If you show this, they're going to think that this is about an attempt at their heartstrings, or this is going to be overdone. So it's really a balancing act. No matter what the consideration is, they have to decide how many is good and at what point does it backfire, and when will the jury think it's way too, strict.
I think that's a fabulous point, Alan, and it's a good comparison to the Grate case, because there they have this horrific evidence that the jury is going to see, and you play that too much of that, and you can actually turn the jurors against you. Just as in this case, you know, some of that demonstrative evidence actually, as Jonna pointed out a little earlier today, actually misfired, no pun intended, in that, you know, it allowed the witness to actually misfire the gun. I do want to update our ladies and gentlemen at home. It looks as though the judge is going to be giving the jurors what basically equates to the Allen charge in just a few minutes. All lawyers know that the Allen charge is the last resort direction from the judge. So the judge has indicated that he's going to give this last resort direction to let the jury know that they would like them to continue to deliberate. I want to get each of your experience with an Allen charge, and I'll start with you this time, Jonna. When a jury gets an Allen charge, do you find, and this is just your opinion, I don't need any statistics, that a jury comes back quick, that they end up deliberating for much longer, or does it really just depend on the jury?
I think it depends on the jury. It depends on how much the one or two holdouts are really holding out. Sometimes it can backfire and just anger the jury. I would not want to have one or two people who were steadfast in their opinion come back and go, well, now I'm forced to renegotiate with you guys. Okay, fine, I'm changing my mind. That's not a fair verdict. We don't want that to happen in this case.
Yeah, Alan, what do you think from your experience? Does this type of charge make a jury stick to their guns even more, or does it actually work?
I think they're already at this point. Even though they're getting the charge, I think there's probably, whatever the split is, one or two jurors or maybe more, but these jurors have said, nothing's going to change my mind. Nothing's going to make a difference. This is how I feel. So even though there are exceptions, from my experience, it seems like this charge will just prolong the inevitable. And it's extremely likely this jury is just not going to move and remain deadlocked.
I couldn't agree more, especially because they've been out so long and had so many questions, Nicole. Do you think that the timing of this charge may be a little too late?
You know, and I think that that's fine. You know, so I wouldn't necessarily say too little, too late. You know, it's always a question whether or not you want to put that kind of pressure on jurors to make a decision. If they wanted to make a decision, they would have made a decision. And I've had cases that ended because there was an Allen charge and they came back with a verdict. I've had it happen in a favorable way. I've had it happen in a negative way. And sometimes it just doesn't work at all. And I think that the timing of this particular Allen charge could actually make a difference. They've had time to really dig their heels in on whatever their opinions are in this case.
Yeah, it's going to be fascinating when this case is over. I would love the opportunity to speak to some of these jurors, because I have just an intuition, and it could be totally wrong, that it's just one or two jurors who are sort of the exceptions. But and you know, you just never know what's going on in a jury room. So to get the opportunity to speak to some of these jurors, no matter what happens, would be just phenomenal, and get a little bit of a sense of what's going on here. We're waiting now for the courtroom to get back in order. here so that we can get back together and see exactly what Alan charge they're going to give. In the meantime, I'm going to throw to a clip of the defense closings talking about some of these issues. But I know, Alan, you need to leave us. So I want to thank you for your insight. It's always so interesting to have your particular insight to the jury deliberations, and I'm sure we'll have you back again soon.
Thank you. Nice to be here.